Thank you.
Okay, to understand that Kimberly will be running the presentation from here with you speaking remotely, of course.
Yes, that's correct, Councillor Cole.
Okay, Councillor Cole. Okay, Councillor Cole, you can go ahead. We're live on YouTube.
Thank you, Fiona. Okay, so welcome to this virtual meeting of the Eastern Committee. My name is Councillor Richard Cole and I'm the chairman of the committee and chairing this meeting this evening. So I'm supported by a number of officers. I think is Beth online? Okay, yes, Beth is online. Yes, so
yes,
Beth,
I am, Chairman.
Thank you. Beth Halland-Smith, Development Manager, Catherine Pearson, who's the area team leader, Kate Edwards, Principal Planning Officer, Lewis Jones, Planning Lawyer, and Kimberly Sohn, who's the Democratic Service Officer who's clerking the meeting this evening.
Mr. Chairman, I'm here, Mr. Barry Devlin.
Yep. So, right, you're here rather than...
As the planning lawyer.
Yep.
Rather than Lewis, yes.
Okay, thank you.
Thank you, Mr. Chairman.
And I don't see Zach Elwood online, so no, so he's not here. Okay. Okay, members and officers, please use the hand raise function within Zoom to indicate you wish to speak, so I can see that. And of course, everyone, please keep yourself on mute when you are not speaking. Can I please ask also that any questions are kept brief and to the point. We'll be timing speeches and an alarm will sound when you have been speaking for 4 minutes. And as per normal, if any member of the meeting loses their connection temporarily, we will pause to allow them time to rejoin the meeting. If the webcast stream fails, then we will have to adjourn until we're able to reset the connection, as that's a legal requirement. So we'll move on to the agenda. Item 1, are there any apologies, Kimberly?
Yes, Chair. We have apologies from Councillors Joan Hegan and Paul Follows, and Councillor Christine Baker is here as a substitute.
Thank you. Did this committee agree the minutes of the last meeting held on 26th of August 2020?
Agreed. Agreed.
Thank you. Kimberly, are there any declarations of interest?
We have a declaration of interest from Councillor John Gray, who has made the following submission. I wish to declare a non-pecuniary interest in respect of this item. I'm a member of the parish council at which this was discussed and withheld my views in order not to be seen as making a judgment prior to the meeting. I am also the treasurer of the Dunsfold Parish Church and have received donation from residents in the village. I have been sent emails from the applicant and the neighbour and other objectors, which have all been connected with documents posted on the website. In a small village, it is impossible not to be aware of these issues and history of dispute. I do not feel compromised in any way, and I intend to attend and speak tonight. Thank you, Chair.
Thanks. Are there any other interests that members wish to declare? Right, move on to questions. Are there any questions from members of the public?
There are no questions from members of the public. However, I did circulate this afternoon 2 documents that a member of the public had asked to be circulated.
Okay, and I'll note here also there was an update sheet that was sent around also.
There was indeed, Chair.
Well, it's put on the website earlier on this afternoon.
Yes, Chair.
Are there any questions which have been received from members?
No, Chairman.
Can I ask the relevant planning officer to comment on whether there are any updates to government guidance or legislation that we should be aware of?
Thank you, Chair. None relevant to matters before members this evening.
Okay. Okay, and just on the question of polling. So, of course, as per always, the polling feature has been set up so votes will be taken by general assent or by using the polling. It'll be polling this evening. And if a recorded vote is required, it'll be done by roll call. So item 7.1, Beth, can you report on applications decided under the new temporary delegation to the head of planning and economic development since the last meeting?
Thank you, Chairman. There's been 1 householder planning application that has been approved.
Thank you. So we move on to item 8, applications subject to public speaking. There's only one this evening. And that's item A1, Lad Upper Ifold House, Upper Ifold, Dunsfold, and proposal for erection of extension and alterations. So, Kate, can you give us your presentation, please?
Yes, thank you very much, Chair, and thank you, Kimberly, for bringing it up on the screen there. So the current application is for the erection of extensions and alterations to a listed building. The application is for planning permission, although there is an associated listed building consent as well, which hasn't been referred to committee and will be determined in line with the with any sort of committee comments with regards to heritage. On the application. If I could have the next slide, please. So here we can see a site plan. The site is a very substantial detached single family dwelling, which is in countryside. And as those of you who attended the site visit will have seen, is in a rather remote area within a relatively small hamlet of similar dwellings. So moving now to look at visuals of the existing building. As you can see, it's a very fine building, which is grade 2 listed. Here you can see the main front elevation within the top photo of the building and the main access driveway there. To the side, as you will have seen on site, those of you who went on site, there is a side access way through to the front of the building to an extension to the side of the existing building, which was constructed in the 1930s, we believe, which is what you can see in the lower image. And it is this area where the proposed extension would be constructed. Sorry, thank you. So here you can see the adjacent property, which sits comparatively closely to the existing building and that existing single-storey 1930s extension, which we saw in the previous image, as those of you who went on site will recall. So the two buildings sit corner to corner, approximately 7.2 metres away from each other. And they're in effect at right angles to each other. You can see here that there is an existing vehicular access to the side of the existing extension. And here you can see a partial rear elevation of the building, which shows particularly the rear elevation of the existing, what's been termed the annex, which is proposed for extension. So in this image, the dormer window that you see there at first floor level would be removed and replaced with an extension coming across that area. So moving now to the proposed plans, here you can see a block plan which shows to the left-hand side there the existing building with the area in yellow as the increase in footprint at ground floor level, which would come out to the level of the existing porch to the building. The building which you can see with red markations there is the neighbouring property at Thatch Cottage. Now looking at the proposed floor plans, here we have ground floor plans with the upper image being the existing layout and the lower image being the proposed layout. As you can see at ground floor level, there are internal alterations and an extension to the northernmost part, which in effect increases the existing porch. The wooden structure which we saw on site increases the width of that over the width of the annex part to the property. And looking now at the proposed first floor plans compared to the existing, which is the top plan, as you can see, the existing has one room currently within the roof space with that dormer window, which we saw on the photograph of the rear. It's proposed that that would now be replaced with a full height first floor, which would contain 3 bedrooms, as you can see here on the plan. And looking now at the elevations, the changes are to the northern end of the building, so to the right hand side of the image we can see here. In effect, at a similar level to the existing relatively small first floor above the annex, that would be extended out further with a full gable to the end of the building, resulting in a sliding roof to the end adjacent to Thatched Cottage. And looking now at the rear elevation, here you can again see those changes. So you can see the first floor being extended out, and the proposed full part gable to the end with the sliding roof down towards the direction of Thatched Cottage. And looking now at the northern elevation here, which is the elevation where the main changes are taking place, you can see the proposed roof form. So with that quite elongated roof slope to the side. And in terms of roof form, there would be a small flat roof which would be concealed by pitch roofs surrounding it, which our conservation officers have commented is a suitable design for the existing building, and has indeed been prepared in consultation with our conservation officers. And to confirm, the officer recommendation is to grant permission subject to conditions and informatives. As Councillor Cole said, that an update sheet has been produced, which was circulated earlier today, and I will just take you through that now to update you. The first matter within the update sheet is that due to typographical error, the numbering of the conditions is incorrect, as numbers 3 and 4 were missed off the schedule. So that in effect means the condition numbers are altered from 5 to 12 to 3 to 10 because of those 2 missing numbers. And I'll give a full, at the end of the update sheet, there's a full amended recommendation which has the correct condition number references. I've also recommended an alteration to one condition which was previously proposed. I previously recommended in condition 8, which now becomes condition 6, that details of a tree protection plan were to be submitted by condition. Subsequent to that recommendation, tree information, including a root protection barrier plan, has been submitted by the applicant and reviewed by our tree officer, who finds the plan satisfactory. So on that basis, I've amended the aim of the policy to ensure compliance with that information which has been submitted, rather than require further information to be submitted, and that's all been agreed by the tree officer. And sort of the main body of this update sheet relates to a number of further representations which have been received. We've received 12 since the report publication and consultation on the amendments. There are a number of issues raised there, and I won't take members through all of them, but in essence it's written there for you to review and consider. And in terms of the officer views on the points raised, these are all noted in the document, and there was nothing in the representations which resulted in an alteration to the detail of the considerations outlined in the report, or to the recommendation. In addition to those further representations received, it was noted in some of those representations that there are 2 existing dormer windows to the front of the property, which aren't shown on either the existing or proposed plans. It's not within the area of works proposed, and it's not a change which is declared on the application form, and it's not something which is shown on the existing plans or the proposed. So on that basis, it's not considered that this is an issue which should result in a delay to the determination of the application, notwithstanding that it's something which does need to be resolved in relation to the concurrent listed building consent application. So in light of that, an additional informative is recommended to ensure that the applicant is made aware that the omission of the dormers from the front elevation is an inaccuracy in the plans, and that this consent does not relate to any omission of dormers, which I don't think at all is what's proposed. It's just a slight discrepancy in the plans with what's actually on site. So in light of all those comments I've made above, the overall recommendation is revised as follows. That subject to renumbered conditions 1 to 10, including amendments to condition 6, and informatives 1 to 4, with informative 4 being an additional informative, permission be granted. And that's everything in the update sheet. Thank you.
Thank you, Kate. So we have 2 speakers this evening. The first, who is an objector, is John Dolden, who I think is online. Mr. Dolden, do you wish to make your say your piece? So you've got 4 minutes. Are you with us?
I am with you.
Good. Yep.
Councillor Cole, yes.
Thank you. So carry on in your own time.
Good evening. My name is John Dolden. I own and live in the thatched cottage next door to Upper Ifold House on the north side. I represent the many objectors in the Upper Ifold community. Upper Ifold is an isolated hamlet set in an area to be designated AONB. The jewel in the crown here is Upper Ifold House, a Grade 2 listed building with a Tudor core and Victorian extension allegedly designed by Edwin Lutyens. Not only is the house a great architectural historically, Edward VII used to visit it with his mistress Lily Langtry. Mosley lived here in the 1920s, and visitors included the then Prince of Wales and Mrs. Simpson. Lady Curzon asked Gertrude Jerkle to design the garden. It was once considered a rural ideal of 2 17th century cottages on one side and a pretty thatched cottage on the other, flanking a magnificent listed building across its open garden. A picture postcard perfect. Upper Ifold House and Upper Ifold Hamlet therefore deserve the greatest protection. The application is based on several unsubstantiated facts provided by the applicant, which planning have taken as read with no intent for independent verification. The tree barrier plan passes through my parking spaces, including the injections, undesirable rural expansion, which RE3 policy dictates should be treated as AONB and not AGLB. Policy HA1, HE3 and HE5, understanding, respecting and conserving the heritage asset, has not been met. Listed building and planning applications should be dealt with together by committee as relevant facts and issues overlap. The design will have an adverse effect on listed building where all pre-1948 structures are protected and considered original. The current local style is half-hipped, gabled and viewed side-on. The current roof line complements the Tudor and Victorian portions of the house and balances the southern end. It also matches the flanking thatched cottage and barnhouse roof lines as seen from the road and represents the local style. There has been no attempt to preserve the house roof line. The proposed replacement roof distorts the building and skyline. Removal of characteristic historical features, one of the 5 roof dormers at the rear, should not be allowed. Wrongly states there was a late 20th century extension, actually it was 19th century. There was no cultural information provided with the application. The 2002 RD1 Rural Settlements Policy covering Dunsfold has not been considered or met. This relates to forms, setting, local building style and heritage of the settlement. Development is in close proximity and overlooking of the neighbouring thatched cottage. 2 new story windows intrude on privacy without any condition to use frosted glass. Distances of windows using the 45-degree rule of the supplementary planning document 2 is much less than the minimum distance. This condition is not met. Its harm of closeness is not mitigated by increasing the closeness. Raising the roof line and style change will distort the visual balance and the increased height of the annex and will dominate the skyline. Poor vehicle access of 1 car width will make the building foundations for a 2nd story extremely difficult. Location plan shows OS house position error. Policy NE1 and Natural England guidance is violated on account of ancient woodland buffer zone being correctly determined. Planning used the applicant's own information, including his tree report and RPA barrier document, as their definitive source of information on this matter. RD2, Upper Ifold House has mistakenly been treated as a single dwelling in order to allow Upper Ifold Cottage to be expanded in excess of 40%. What is proposed is in fact a new semi-detached 4 or 5 bedroom house in the countryside, developed from a small 1-2 bed annex, increased footprint. It violates many policies relating to impact on historical building in an AONB setting, visual and residential amenity and biodiversity. I urge you to refuse this application.
Thank you. Second speaker is Dixon Dorbin, who is the applicant. Is Mr. Dorbin online?
He is online.
Yes, can you hear me?
I can hear you. Yes, we can't see you yet.
I can see me on the bottom.
No, yep, you're there now. Good.
Right.
So,
okay, we ready to roll?
Go ahead. You have your 4 minutes.
Thank you. We seek approval to add just 1% to the footprint of our family home in a fully screened setting. It is, I submit, a modest proposal, falling well within local and national planning policy and law. We have anxiously scrutinised every objection made on the planning portal. We have sought to engage with every stakeholder. I'm grateful to Alan Grant for his contribution. Whilst we did not agree with the substance of that objection, we gave careful thought as to how we could allay his concerns as far as possible. Our plan has no impact on the landscape, as he suggested, because it cannot be seen. However, we have respected Alan's comments by limiting the footprint to within the dwarf brick wall and lowering the new gable end without compromising the cat slide roof leading down to the new entrance. With respect, I submit that the remaining objections, including those you've just heard tonight, not only have no basis in planning law or policy, but have no real basis in fact. Drawing 09 in our loss of light report dispel any claim that thatched cottage will be harmed, let alone dominated by our plan. Bats are a happy feature of Upper Ifold. The Surrey Wildlife Trust raised questions any responsible householder would expect to see. And ACD Environmental, the respected specialists who undertook a thorough site investigation, have fully answered their queries. We follow ACD's instructions meticulously. In respect to the south side of the house, even if it were a legitimate objection to propose alternative living arrangements, I would ask the committee to consider it is currently inhabited by a couple who have lived there for 5 years. It is on 3 floors. It has a narrow, winding staircase and is not at all suited for a young family. Planning is all about context. And as the planning officer has confirmed, and several of you have seen, the context here is a plan which improves the historic architecture, poses no harm to its heavily screened environs, converts outdated accommodation into a modern home for a young local family who otherwise could not afford the space they need in the borough. Tudor glassmakers from Lorraine built Upper Ifold. A century ago, Sir Max Bon built a major extension in the arts and crafts style. It was designed to dominate his thatched cottage. He built that as a bungalow, to which a substantial first floor roof extension was later added. During the war, refugees turned his garage and undercroft into a dormitory, later a staff flat and then a rented cottage, all before we arrived 21 years ago. A wartime dormitory fails today's standards. With our daughter, we will repurpose it. Alice came here when she was 9. School friends live in the village. Her husband Ben's ancestors lie in the churchyard, Dunsfold Church, where they were married and where their first child, Lara, was christened. In Brixton, Bristol, and now Surrey, Alice has 10 years' experience as a qualified teacher. As a key worker, it is our council's strategic objective to retain locally. Over 40 years, Jane and I have restored 5 listed homes, including a derelict Upper Ifold. Ben, our son-in-law, runs huge professional building projects. This one will be done by us to the highest standards and with loving care. The north end of our house will blend once more with the arts and crafts style. With 5 adult children and multiple grandchildren, our large house is already fully used. To keep 3 generations living here, supporting each other, our family needs this extra space, and I respectfully ask the committee to support our plan. Thank you.
Thank you very much. Thank you. Okay, move to the debate. So are there any speakers, any member who wishes to speak?
Councillor Darcy and Councillor Gray, Chair.
Thank you. Yep. Councillor Darcy.
Yeah. Okay. My concerns are, it's a slightly esoteric point, but in policy RD2, which is about extension of dwellings in the countryside, it talks about dwellings. So I'm trying to get a definition of what a dwelling is, because there seems to be some discussion about this. Is this one household or is it 2 household? And is a dwelling the building, or is it the part of the building inhabited by different families? Because this seems to me quite pivotal, because the extension itself, if you look at the footprint, the actual bit of the annex that's being expanded is more than 40%. Of the whole building, it's much less than that. So that seems to me quite a key question, and I haven't really had a suitable answer. So what is a dwelling versus a building versus a household?
Yes, thank you very much, Councillor Darcy. I would say that in planning terms, the definition of a dwelling is fairly loose. In essence, the definition is that it's a building which is occupied in accordance with use class C3, i.e. as a dwelling house. So the legal definition in that sense isn't particularly useful when it comes to the interpretation of policy RD2. What I would say in terms of RD2 is that it's very clear that the existing building is occupied as a single family house, and that the annex, although occupied by different generations, is used on an ancillary basis with the main house and isn't an independent dwelling. In terms of the visual test of proportionality, I think it's quite clear in this instance, based on fact and degree, that it should be assessed against the whole building, the whole house, rather than just the annex. And in that respect, the proposed extension is really quite minor. Thank you.
Councillor Gray.
Thank you, Chairman. I think that everybody's observed there's been an awful lot of changes on this application, and there's been a few complaints about the delays in posting documents and finding the officers' reports. And that's around the many objectors from a wide area, and not just this local hamlet. And it reflects the importance of this house. It's noted the Historic Buildings Officer has not made any adverse comments on the effect on the listed building. And although the separate listing building application was not called in, and that was a mistake on my part, it is relevant to this application, and I believe the officers confirmed that, so that the Historic Listed Buildings Officer's comments have been incorporated into her report. Upper Ifold House, with Lutyens and Jacob connections, is an important historic building within the hamlet and also within the parish. Formerly part of the house and grounds, there are a number of separate dwellings, including thatch cottage, garden cottage, and the barn house. The ancient woodland around it is a bit difficult to identify, but certainly the Surrey interactive map puts the ancient woodland at between 10 to 13 metres behind the existing rear part of the extension. When the development is extended, that will be very marginally increased, but it's still very close. And it's not just the question, the existence of the tree. The ancient woodlands, and I've had lectures on this by members before, it's not just the trees that are defined there, but it's the area, it's the soil, it's the ground covers, it's the habitat. And notice that there has been no survey of the woodland, and the proximity of the house and the extension to that woodland is extremely close. I know the existing extension is close, but one issue made some 30, 40, 50 years ago is not a reason why we shouldn't basically examine and look at it from today's MPPF and sets of rules. There can be no doubt that the closest neighbour feels there is harm, and as has others, raised a number of objections. The applicant has made a declaration, supplied information on his own right, which has been accepted by the officer. Some of it's without independent verification and is disputed by objectors. Should this application be approved today, then I would suggest that condition 3, now brackets 5, should make it clear that HGV delivery should be made to the end of the drive by the lane and not then transferred by other means down the site. I think that clause of condition in there needs to be strengthened slightly so that we do not try and get very large vehicles down that very narrow lane. And also I would suggest that we should look at those windows that overlook Thatch Cottage on the second floor should be glazed to minimise the overlooking. They are overlooking and they look directly into the house and they directly impact on the amenity space of that house. I'm pleased that the new informatives have been added. Can't see how those 2 windows were missed, but I was very grateful to the officer for picking that up and putting a new informative forth. Very difficult application for me. I'm very much trying to balance all the views. I reserve my position and I'd be very interested to hear other members who are slightly separated from the local issues, comments before I make my decision at the end of the meeting. Thank you, Mr. Chairman.
Thanks very much. Councillor Wilson.
Thank you, Chairman. Just a couple of things. I have been in contact with the planning department about a couple of concerns I had, because when I first looked at it, I thought it was going to be a semi-detached, quite large building. I've had answers to say that I think my concerns have been met by the conditions and planning law. However, there's a couple of things I'd like to query. One is that looking at the relevant planning history, it says nothing, well, it says on the main document about a 1930s building. It also says on this that in 2013, an extension was erected following the demolition of a summer house. Is this the same extension that we're talking about?
No, it's not. That was an extension which was predominantly to the rear, in an area where sort of bifold type doors were put in. It's not the current extension to the side, and it didn't propose any works within this area to the side.
That's fine. And the other query I've got was about the bat roosting. It says that they were quite happy with a small area of tiles being moved. But I see the definition says that the officer's opinion is it's a small area. Do we not have a defined small area from these people?
So since that point, we've received further comments from Surrey Wildlife Trust, who initially left it with officers to make that judgment about whether it was a small area or not. But we received further comments from Surrey Wildlife Trust saying they wanted the scheme ecologist to confirm that the area of broken hanging tiles to be removed was small. And the ecologist has indeed since confirmed that. So from that point of view, it's in line with Surrey Wildlife Trust comments. And also just to point out in terms of the hanging tiles to be removed, it's not that the applicant is proposing to remove those without any mitigation of or other factors. It's just that they're proposing not to, or they have rather, they haven't submitted a detailed bat survey, because when they remove the hanging tiles, they're going to do an endoscopic investigation where they'll pass a small camera in underneath the tiles prior to removal to ensure no bats are harmed whilst they're being removed. So the fact that that route is chosen as to sort of determine the impact on bats doesn't mean that they're going to be, you know, damaged in any way. Thank you.
Okay, thank you for that. It was just a question of our officers taking responsibility for something that's not in their area of expertise when there is somebody who has that expertise, but it sounds as though it's been done correctly. Thank you.
Councillor Goodridge. Councillor Goodridge? I think we've lost Councillor Goodridge. And
Yeah, I've got it. Sorry, I pushed the wrong button.
okay,
thank you, Chairman. Can I say that I found the site visit very beneficial? It certainly put the context of the extension and thatch cottage into more focus. I found the footprint footprint of the extension helpful, because it just showed, I think there's a small little retaining wall that goes along at the side of the drive, and the extension is going to be within that, as is shown by the footprint. I note what Councillor Gray says about glazed windows, and which face towards Thatch Cottage, and I see from the first floor plan that it would appear to be 2 bathrooms and a utility room that are facing the front of the house, and the bedrooms all face the rear of the property on the extension side. So perhaps glazed windows might be appropriate in those 3 windows. I have to say that looking at the thing in the whole, and I'm obviously grateful for anybody else's comments, but I feel myself that the officer's recommendations are correct, and that unless I hear anything to change my mind, I will be supporting the officer's recommendation. Thank you.
Councillor Townsend.
Thank you, Chairman. I've just got one query regarding the bat survey, or rather the absence of a bat survey. I note, and thanks, Kate, for your comments regarding the removal of the tiles, and that it was up to officers to decide whether or not that was a significant area or a small area, and that you have included in the report that officers consider that their proposed works are not likely to have an adverse impact. However, I mean, I'm a little bit confused, because Natural England's standing advice for when a survey should be carried out, I thought was quite clear, especially where a bat roost was present on the development site. And I just want to know why it was decided that an ecology statement was sufficient, and that in this particular application, which has already highlighted that there is a bat roost on the site, that a full survey was not carried out. Thank you.
Kate.
Yes, thank you very much, Councillor Townsend. So in essence, the surveys have been carried out in compliance with the early advice we received from Surrey Wildlife Trust. In relation to the roost, which is to the southern end of the building, the ecological survey which was undertaken didn't identify any use of the roof space where the works are proposed by bats, and the scheme ecologist has subsequently confirmed that the main roof slope where there is a rooster immediately the other end, has been totally separated off from the roof space above the annex where works are proposed, so that it won't have any possibility of having an impact on the existing roofs. In terms of the hanging tiles area, as I understand the relevant guidance from Surrey Wildlife Trust comments, it is acceptable to carry out another form of investigation as to whether bats are present through using an endoscopic survey when removing hanging tiles, in circumstances when only a small area of hanging tiles will be removed. So according to Surrey Wildlife Trust interpretation of the guidance, that is acceptable. Subsequent to the committee report, we officers have received confirmation from the scheme ecologist, which Surrey Wildlife Trust did request in relation to the hanging tiles to be removed. And if I quote that to you, the scheme ecologist has said it can be confirmed that the areas of hanging tiles to be affected are easily accessible and are limited in size, being approximately 0.5 metres squared on the eastern side and approximately 1 metre squared on the western side. So the scheme ecologist has confirmed that it's a small area, and in their professional opinion, it would be acceptable to investigate that presence by endoscopic investigation prior to removing the tiles. Thank you.
Councillor Baker.
Thank you, Chairman. I would like to return, if I may, to the question of when is an annex an annex. I'm assuming that we should be making our decision on the basis of the fact that the earlier extension, which is closest to thatched cottage, is actually an annex. I'd like to be reminded, please, of what happens if the owner of Upper Ifold House decides that it should no longer be an annex, but should be a separate dwelling. And because we are being asked to approve something on the basis of the proportionality of the extension. So please, could I have my mind refreshed?
Kate.
Yes, thank you very much, Councillor. So in terms of the existing building, it's very clear that the annex is occupied by the same family and the existing use is ancillary to the existing building operating as a single family dwelling house. And the applicant has applied for an extension to that single family dwelling house rather than a subdivision and extension to create a new planning unit. Because I've recommended a condition requiring that the use of that space remains as ancillary, the applicant would be required to gain full planning permission if they ever in the future, they or their successors in title, wanted to use the annex as a separate, completely independent dwelling, which wasn't occupied by family members of the main house. So if were that to be the case in the future, the planning application would be assessed as any planning application for conversion and subdivision of a dwelling, and would need to meet the various criteria that were in force at that time.
Thank you. May I come back, Chair?
Yes, please carry on. Yes.
Thank you. Just to flog this to the bitter end, we have had applications and do regularly get them for certificates of lawfulness for use in very similar circumstances to the one I'm describing that might occur in the future. So I find myself in a bit of a bind here because I suppose what I would like is stronger to find that the second position where the family might sell the extension as a separate dwelling, I I don't really think that we have very strong position on protecting the ancillary arrangements. So I'm giving this some thought, because I suppose the officer will advise me, and thank you very much for your help, that we have to make the decision on the basis of how the situation is now. Is that correct?
Yes, that is correct. We need to consider the plans that are before us, and a non-ancillary use, so use as a totally independent dwelling, would need planning permission. If the building were to be occupied as a completely independent dwelling without gaining that planning permission first, then there would be a planning breach, which would need to go through the usual processes. So in terms of the decision on this application, we take the application as it is, as what's before us and what's submitted, which is annex accommodation, which will serve the same family and will be occupied on an ancillary basis to the main family, single family dwelling house.
Thank you very much.
Okay, just so I'm clear, at the moment, planning permission situation is that to convert this to a separate dwelling is entirely under the control of the Borough Council. There's no statutory right to do that under current legislation. Is that correct?
If a separate planning unit is created within a C3 unit, which the building is, then planning permission would be needed.
Okay, thanks very much. Councillor Else.
Thank you, Chairman. A few points. I also, like Councillor Goodridge, found the site visit very useful to put the whole thing into context. And I obviously sympathise with Mr. Dolden that his little rural is going to be disrupted by this extension, but I can't really see that it's going to have a major impact on the thatched cottage. I would agree that obscure glazing could be conditioned for the 2 bathrooms and the utility room to avoid any overlooking of thatched cottages' private amenity space. Mr. St Alban in his presentation said he was looking forward to having the house completed as an arts and crafts style unit. I would have to say that I would hope that the listed building consent, when that is considered, will consider conditions asking for detailed drawings of various elements of this extension, because at the moment the drawings as presented to us, without being unkind, look like something an estate agent has knocked together in a couple of hours, rather than paying the due care and attention that I would expect of a listed building. But they do show the detail that we need to have, but it's usual for listed buildings to have to request a condition that asks for larger scale details of various roof details, window details, dormer details, that sort of thing. I'm a bit concerned. I mean, I did ask the officers to ensure, I noted an earlier version of the plans didn't tie up between elevations and plans, floor plans and elevations. I asked them to ensure that revised drawings were submitted. So I'm a bit concerned to hear tonight that dormer windows, which are a fairly important part of any elevation, have been left off drawings. So I really hope that when the listed building is considered, that our officers will apply the correct conditions. And just to finish up, Chairman, the discussion about what is an annex and what isn't an annex. The plans do show connecting doors at both ground and first floor levels. And as someone who lives in a house with 3 generations, with defined areas but interconnected areas, I'm sure that if the residents of Upper Ifold should suddenly find themselves renting it out to strangers, and I'm sure that the neighbours will be the first to get onto our planning enforcement and make sure that they toe the line and apply for the necessary permissions. Thank you very much.
Kate, can you just give an assurance to Councillor Else that the listed building consent will consider the matters he listed?
Yes, yes, certainly, Councillor Cole, and Councillor Else. Certainly, you're very correct that in relation to a listed building application, we'd normally look for small-scale drawings, and the Conservation Officer has recommended to me a number of conditions to be attached to listed building consent, should it be granted. So, should we proceed down that route, following the committee would certainly be attaching those conditions. Equally, the issue in relation to the dormer window. Unfortunately, I checked the proposed plans and elevations against each other, but not on the front elevation against what was on site. But I would be expecting the plans to be amended to show those existing dormers prior to the listed building consent application being granted. Thank you.
Thank you, Kate. Thank you.
Barry, do you want to jump in?
Thank you, Mr. Chairman. Just addressing Councillor Baker's concern about the annex and the council's control over the possible future use of that annex and separation of main dwelling. I haven't had a chance to speak to Kate about this, but might perhaps suggest that planning obligation be entered into to ensure that that annex is never sold off, leased, gifted, or party with possession separate to the main dwelling without the prior consent of the council. Section 106 agreement is more strong control than a planning condition. It is registered as in land charge register. A purchaser would buy with notice of it. Discharge of planning obligation requires a complex process. Under the Town and Country Planning Act. It's a strong control. I don't know if members might be minded to require the applicant to enter into a Section 106 agreement along those lines. And that's all I have to say, Mr. Chairman. Thank you.
Kate, do you think that would be a good idea?
So that would be a very absolute way of ensuring that it wasn't used as a separate dwelling. However, in my view, that isn't necessary in terms of the recommended condition that would prevent ancillary use and mean that planning permission would be required, and equally would be seen by subsequent purchasers in the same way that a legal agreement would when they were reviewing the consent for their property, were there to be a situation in the future where it was attempted to be sold independently, which is all very hypothetical. So it's my view that a legal agreement isn't required, but obviously Barry is our legal expert, so I don't know whether you think it might be appropriate for us to have a further offline discussion about that.
Catherine, did you want to come in on that matter? Catherine?
Thank you, Chairman. It is a possibility to use a legal agreement. However, in this case, we do have the control. We have control anyway in terms of the lawful planning unit as a single family dwelling. That's its lawful use, and any breach of that we would be able to investigate under our enforcement powers, and we would be able to seek, either for the use to cease or for a regularization of that. So I'm not sure that in this instance a legal agreement is the right thing to suggest. In any case, a legal agreement, whilst it offers an additional level of control, as Barry said, of course, we don't want to find ourselves in a position where we've applied a legal agreement and then we find that that legal agreement no longer serves a useful planning purpose, i.e. if a breach occurs and becomes lawful through time immunity, etc., or indeed if we apply our relevant development plan policies to find that a conversion may well be acceptable in this location. Of course, this is the countryside, it is not the green belt, it is not subject to the very highest levels of control. That's not to say that other considerations around sustainability would mean that a conversion of the property is acceptable in this location. Certainly there is support in some policy instances for the conversion and subdivision of properties. So in my opinion as a planner, I don't feel that in this instance, given the circumstances of this application, and as Kate said, its proximity around other dwellings, that a legal agreement would offer much more assurance on the use than either just a permission in its own right or indeed a permission with a condition. I'm not sure if that clarifies, but I'm happy to take any further questions on that. Thank you, Chairman.
I guess this is really a moment between the officers. I mean, Barry, do you want to push this line of requiring a 106 agreement, or was it advice that could be taken up if needs, if the planners thought it useful?
Yes, Mr. Chairman, a Section 106 agreement would give you a very significant degree of control, but the planning officers advising you are very experienced, and I have great respect for their views. If they feel in the particular circumstances of this matter a 106 is not required, a Section 106 agreement is not required, I'm not going to strongly advise that the committee needs to have one in place.
Thank you. Councillor Dinas.
Thank you, Chair. It seems a lifetime ago since I put my hand up. It's been a busy debate. Most of my points have now been covered, so I shall ignore all the points I wanted to raise and just make a couple of observations. Firstly, about Councillor Gray, a very difficult one for him to speak on, but I think he's given a very balanced approach. I support everybody who talks about having the glazed windows, so if we can make that a condition. But the one point that Councillor Gray made, which I don't think we've really touched on again, is about the lane and the HGVs, and obviously HGVs having to stop at a certain point. I think it was mentioned and we've moved on. So I just want to reiterate, I support Councillor Gray on that, and I'm sure when he speaks again, excuse me, I see his hand is up, he may well be suggesting that as a condition. If he does, Chair, I'll support that, but I won't go over all the other points.
Yeah, Councillor Gray's points have not been ignored. They were down on my list to come back to at the end. Councillor Reid. Councillor Reid. We lost Councillor Reid.
He's there, Chair. We can't hear you, Councillor Reid.
We can see your the mic's moving, but Ruth, Councillor Reid, do you want to try and work on that? We'll come back to you in a moment if you can resolve it. Okay, we're down to the last three speakers have already spoken. So, Councillor Gray, presumably you'll come back to the points you raised earlier.
I will do. I just wanted to come back on one point, and that was a very helpful comment from the officer about the ancillary dwelling. And she mentions the word same family. And looking at condition 6, I wondered whether it was possible to add in there ancillary dwelling for the same family. Without that, then I think that it could be open to interpretation. I know it's the applicant's intention to have this family in there, and I think we've heard some of our concerns. So if we could add that to that, then that would help from my point of view to clarify. Thank you, Mr. Chairman.
When you say the same, you mean one family, presumably, because I mean this condition has to apply in future. So it's one family. Same family, sir. Okay.
That all of the individual elements are part of the same family. That's what I'm suggesting.
I understand. Well, as do you wish to? You proposed 2 amended conditions, I believe. One was to to do with the HGV access, and the second was the obscure glazing to the upper windows. Do you wish to propose those as amendments to the permission?
Yes, I will. I'll propose 3 amendments. One is that clause at condition 6, the same family is put in there. On the question of 3/5, that's the construction management plan, that a limit is placed on the size of vehicle going down there, and I don't know how to word this, but that basically is that loads are basically transferred to smaller vehicles to go down the lane. And the third point, and I don't know where you would put it, have to be a new condition about the glazing in the overlooking. Those would be my 3 amendments, Mr. Chairman.
Yeah, we'll deal with those. Yeah, we'll deal with those separately, I think.
Sorry?
I think I'll deal with those separately in terms of discussion, but sorry, you were going to say.
Okay, sorry. I need a seconder first, but.
Okay, let's discuss condition 3 about the HGV access. I think it's because officer commented this is could have quite profound impact on the building programme.
Yeah, yes, Councillor Cole, if I could come back on just those 3 conditions. In relation to the construction logistics plan, the condition as worded is for a plan to be submitted rather than, aiming in itself to ensure that no HGVs come on the road. So the condition as worded does give us the opportunity to secure that. The applicant does say within the information submitted with the application that it's their intention in any case to carry out various construction activities like storing materials off site and using smaller delivery vehicles. So I would hope that matter could be secured when we get to the stage of considering a construction logistics plan in detail. And equally, having driven down that lane myself when visiting alone, I don't expect that they would attempt to use it for an HG vehicle, given the size of the lane. But so in essence, I think that's something which we would be able to secure at condition stage and doesn't necessarily need to be in the detailed wording of the condition. In relation to obscure glazing to the windows to the eastern elevation facing on the side which adjoins Thatch Cottage, I don't see any reason why they couldn't be conditioned as obscure glaze if members feel there is a concern about impact on privacy of those windows. And as you've stated, they're not functions which require a level of outlook like a living space. So on that basis, that would be acceptable in planning terms if there's a privacy concern. In relation to the wording of the ancillary condition, I think it's probably appropriate if I ask the development manager if she's able to respond on that point. Thank you.
Catherine, do you want to comment on that point?
Beth is the development manager.
I'm sorry, Beth, excuse me. I just read my list. It says right in front of me. I can see it. Thank you. Beth.
Thank you, Chairman. In terms of restricting, rewording the condition to include reference to the same family, I would suggest that would go a little too far in terms of setting control over this annex. It is a well-held principle in planning terms that, for example, a housekeeper can be an ancillary, a housekeeper's accommodation, gardener's accommodation. This can all be ancillary accommodation. The test for ancillary accommodation is whether something is functionally and physically connected to the main dwelling. So it is not the relationship per se between those occupants, but the interrelation, if you follow me. So my advice to you would be that to include reference to the single use by a single family could be construed to be unreasonable in this case. Thank you, Chairman.
Okay. Sorry, Barry, you've got your hand up. Is that something you want to add?
Yes, yes, just to support what Beth just said about that concept of the same family. I also think it fails to test the precision that an enforceable planning condition requires. Because I think the years down the road, the individuals obviously will change by reason of various events, life events. And I fear that definition could be difficult to sustain in years to come. So I'm slightly uncomfortable with that precise wording, Mr. Chairman.
Thank you. So, thank you. So, Councillor Gray, you've got advice from officers there that it's not necessary to amend the transport condition because it has yet to be agreed, and putting same family was legally inadvisable. Do you wish to proceed with those amendments, or just with the one concerning? Carry on.
If I could come back, I would point out to Kate that her comments about the road being too narrow for large vehicles, and I have many examples of two large vehicles trying to go down a very narrow space. Especially in this village, there are a lot of very narrow. I do think that the applicant was very clear in offering something, and I read it in the submissions. So I will accept what the officer is recommending on that, as long as we get something that makes it very clear that it's basically something that everybody understands. So I'll put the onus on the officer to make sure that the plan is agreed. On the question of same family, I understand the point. I'm disappointed because it was mentioned in passing, right? I can't remember who it was by, either by the officers or someone else. I think, you know, are you saying that the tennis coach of the family can go into there, or if there's a housekeeper goes in there and the person no longer becomes a housekeeper? I don't want to take that too far, but they're my concerns. I have listened to what the officer said, and I will withdraw that condition. So if we could make sure we emphasize the management plan, right, and we'll leave that to the officers, but if we could include the glazing, right, as an additional condition, Mr. Chairman, I'd be happy to propose that single addition.
Is there a second to Councillor Gray's motion on the condition to do with glazing?
I'll second that.
Councillor Dean.
Okay, that's seconded. Do we have to vote on that one? It seems, in general, is that acceptable? Anybody object to that?
Yes, I do. I have a thought to add, if I may, Chairman, about the obscured glazing. This is the front of part of a listed building. I think obscured glazing tells everybody as you approach that it is not, what you would not necessarily expect a series of 3 glazed windows on at first floor level on the approach to a listed building. I just have doubts about it. I don't think we've got a historic buildings officer here, have we? But I wonder if that will actually be acceptable to the historic buildings officer. Okay, well, we've got a proposal. It's been seconded. We'll move to a vote in that case. Yeah, fine. So Kimberly, do you want to start the voting process? So we're voting here for Fiona. Sorry, Fiona, of course. So the proposal is additional condition is added that the windows, I think it was 3 windows to the front, be obscured glazed. Please vote.
You should be able to see that on your screens now.
Yep, I can see it at least. Okay,
so that's in favour and 3 against.
Thank you. Councillor Reid, are you able to to speak now? Or can we hear you this time? Councillor Reid?
No, Chairman, we can still see her speaking, but she's not coming through.
Okay, well, carry on, just in case she can make herself heard. Okay, the last, I think I've got Councillor Baker, no, Councillor Wilson, Councillor Gray, presumably you've said your piece. So, Councillor Wilson, would you want to come back briefly?
Yes, very briefly. I would feel better with the belt and braces suggested by our lawyer, the 106 agreement. I really do think that ancillary can be misinterpreted quite easily. But that is purely my opinion. I don't know if others agree.
Well, you could propose an amendment and see whether someone will support you. Isn't that the test?
In that case, I propose we take Barry's advice as a lawyer and go for the 106 agreement.
Is there a seconder to Councillor Wilson's
Yes,
proposal?
I will second Christine Baker.
Okay. In that case, we'll go to a vote. Can we? So I understand the motion is that a Section 106 agreement be entered into, which further defines the occupation of the total property.
That's
so, okay, thank you.
And so, oh.
Okay, before we start voting, did I hear Kate?
Yeah, so apologies, Councillor Cole. I would just say that if we are moving to amend the decision to require that a legal agreement is completed prior to the consent of the grant of consent, we would also need to add in a recommendation B with that to say that planning permission should be refused in the event that that legal agreement isn't forthcoming, i.e. members must consider that this issue is intrinsic to the grant of consent in terms of having the legal agreement. Thank you.
Okay, so given that it forms two parts, the original proposal from Councillor Wilson and then the additional part that Kate has just given us. So we move to vote on those two together.
I'm not clear now, sorry.
Okay.
And in fact, I'm quite prepared on
Hang on, no, we've got the motion. It's clear. It is that the original motion, well, the first part is the Section 106 agreement be entered into. And Kate has pointed out if we do that, then we have to add a second part, which is if that is not successful, then permission be refused. This is standard stuff. This is what appears. So it's Section 106 agreement to do with the occupation, and the rider that if that's not entered into, permission is refused. I think that's clear. So please vote on whether those should be added as additional conditions.
One person who appears not to have voted.
Okay, everyone, please check they've voted.
I haven't got the polling window up.
Okay, can you indicate which way you wish to vote on the motion, Councillor Baker?
In view of what I've been told, I wish to vote against the Section 106 proposal.
Okay. Okay, thank you. Fiona, do you want to read it out? But it's clearly been lost. Okay, the motion's been lost. Okay, so Councillor Wilson, you've spoken. Councillor Reid, I know you're struggling here to make yourself heard.
Chairman, could I suggest that Councillor Reid, perhaps if she's got a specific question, could put it to Fiona, and perhaps Fiona or Kimberly could read it out, perhaps?
You mean via the chat facility?
Yes, because you can contact Fiona via the chat.
Yeah, Councillor Reid, that seems to be your best bet. I assume you can. I presume that Councillor Reid voted last time around. So she has connections to vote, but it seems it's a speaking bit that's difficult. While we wait, Councillor Baker, you're showing your hand up. I presume you've now spoken.
You're muted.
Sorry, I'm taking that down now.
Yep.
Sorry.
Thank you. Councillor Reid, I think it's probably the last chance you'll have to make yourself heard.
She's indicating she doesn't want to speak.
Okay. In that case, that's the last speaker. So we can move to a vote on the amended proposal. So it's as in your, sorry, the additional, excuse me, the additional paper that was, sorry, one piece of paper, the amended, the update sheet that was provided to you this afternoon with the additional, I guess it'll petition 11 to do with the addition of the obscured glazing, which was agreed there. I think that's correct, Kate, isn't it? Is Kate online?
Sorry, Chair, apologies. I was just trying to unmute myself. That's correct. So the recommendation is as amended at the bottom of the update sheet, and with the obviously the agreed amendment to require obscure glazing of the windows. Okay. So subject to renumbered conditions 1 to 10 or 1 to 11, including amendments to condition 6 and formed as 1 to 4, permission be granted. So that is the motion. Please vote.
That's 11 in favour, 2 against and 1 abstention.
Okay.
So the motion carried.
Motion's been carried. And I believe that is the last item for this evening. So thank you very much, members, and good evening.
Thank you. Good night.
Yes,
Thank you, Chairman.
Good night, everybody.
Chair, good night.
Good night.